On a Saturday session inside the Supreme Court chamber, Melania Trump gave live testimony under oath. Within hours, emergency seizure orders followed. By Friday morning, U.S. Marshals were executing them. Court documents referenced $1.2 billion frozen, 17 properties seized, and 347 bank accounts across 6 jurisdictions locked down. The speed was unprecedented. The question was simple and unresolved. What did the court see that demanded action within 4 hours? Court filings show Melania Trump entered through a private entrance at 7:14 a.m. and did not leave until 6:47 p.m. Her testimony was not a written statement or a closed deposition. It occurred in person before all 9 justices. Transcripts initially ran 14 pages with exhibits spanning roughly 380 pages of financial records and internal communications covering 8 years. The subpoena had arrived 2 weeks earlier. A special counsel sought her testimony on presidential immunity and asset forfeiture linked to multiple federal indictments. Filings indicate she held signatory authority on 14 offshore accounts previously unknown to investigators. She did not invoke spousal privilege. She did not plead the Fifth. When her testimony concluded, Chief Justice Roberts called an immediate conference. 4 hours later, emergency seizure orders were issued. By the next morning, U.S. Marshals were moving on domestic properties tied to flagged accounts. Emergency orders from the Supreme Court are rare. Issuing them within hours is rarer still. What shifted the court from deliberation to urgency? The filings outline why the hearing escalated. On page 47, the court records documentary evidence of 17 wire transfers from accounts held jointly with her spouse, totaling $804.7 million, directed to entities in Cyprus, Switzerland, and the Cayman Islands. The transfers occurred after federal freeze orders were supposed to halt all movement. Page 112 went further. Bank confirmations showed timestamps placing additional transfers after a November asset freeze. The timeline presented to the court was specific. November 14, 2025, assets frozen pending trial. Between November 19th and December 3rd, funds moved anyway. Additional transfers followed through December and January, including $340 million routed through a Nevada LLC. None of this relied on inference. The records were attached, but the contradiction remained. Who authorized transfers after court said they could not happen? Then came Exhibit K. On page 189, filings indicate Melania Trump was asked to sign transfer authorizations without knowing their contents. Her testimony stated she believed they were routine business matters. Her legal team objected to the submission of Exhibit K. The objection was overruled. The exhibit was entered voluntarily. The document carried her signature dated November 22nd, 5 days after the freeze order. If that signature stood alone, it suggested exposure. But the surrounding documentation complicated the picture. Why would someone sign after a freeze, then bring the paperwork to court? The answer may sit on page 211. That filing included personal handwritten notes from conversations about the transfers, dated December 14th. Portions were redacted, but visible sections referenced reassurances and claims that court orders did not apply. Those notes were contemporaneous. They were not prepared for litigation, and once the justices reviewed them, the court moved at a pace it had not shown in more than 2 centuries. The immediate impact was visible. 17 properties across 4 states and 3 countries were identified in filings. U.S. Marshals could act only domestically, and they did. Mar-a-Lago was entered at 6:12 a.m. Trump Tower followed at 7:34 a.m. Bedminster at 8:15 a.m. 7 additional properties were secured by noon. All domestic assets connected to the flagged accounts were frozen pending a full forfeiture hearing. The assessed value reached $1.2 billion within 36 hours of testimony. But the asset seizures were not the only development. A separate filing, docketed at 11:47 p.m. under case number 241847, made a criminal referral. It did not target Melania Trump. It targeted 3 attorneys who had advised on the transfers. By Friday morning, before Marshals completed domestic actions, 2 of those attorneys attempted to leave through Tedarboro Airport. Customs stopped them. Passports had been flagged overnight. The 3rd attorney surrendered voluntarily that evening. All 3 faced obstruction-related charges tied to the transfer advice. This sequence mattered. It suggested prosecutors believed the testimony that legal advice, not independent action, drove the transfers. It also raised a new question. Was the focus shifting from assets to advisors? Supporters of the president argued the testimony was coerced. They noted she was subpoenaed and did not volunteer. They pointed to spousal privilege and centuries of common law meant to shield marriages from government pressure. Some called the process unprecedented and argued verification needed on whether pressure crossed legal lines. Others countered that spousal privilege must be invoked to apply, and filings show it was not. That debate remains unresolved. What is clear is that the court recorded her voluntary submission of additional exhibits after her own lawyers objected. Another uncertainty remains central. Did Melania Trump receive immunity? The filings do not say. Prosecutors have not confirmed or denied any agreement. Any assumption either way requires verification. Procedurally, the case now sits at a critical junction. Asset seizures are temporary unless upheld. The Supreme Court is set to hear arguments on whether the emergency orders should become permanent pending trial. If upheld, forfeiture proceedings begin. If modified, assets could be released under conditions. The criminal referrals against attorneys introduce a parallel track. Charging advisors first is a known strategy. It builds a record, tests cooperation, and establishes intent without immediately escalating to principles. One attorney has already sought cooperation during arraignment proceedings. That move alone suggests the investigation is not static. There are limits. Pardons do not apply to civil forfeiture. Executive privilege has already been litigated and lost. Any attempt to characterize outcomes beyond the filings would require verification. What does the evidence show, and what does it not prove? It shows transfers after freeze orders. It shows signatory authority. It shows advisors now facing charges. It does not, on its own, resolve intent at the highest level. That remains the court's task. The immediate calendar is fixed. Monday, February 9th at 10 a.m., the three attorneys appear for arraignment in federal court in Washington, D.C. Tuesday, February 10th, the House Oversight Committee convenes an emergency hearing on executive asset management. Thursday, February 12th, the Supreme Court reconvenes to consider whether seizure orders remain in place. Friday, February 13th, is the deadline for the Trump legal team to respond to the forfeiture motion. Between now and Thursday, filings can still land. Courts remain active in emergency cases, including weekends. The record already includes Exhibit K, handwritten notes, bank confirmations, and testimony accepted as credible by the justices for the purpose of emergency action. Is this cooperation, coercion, or something in between? The filings suggest a complex mix of legal exposure, documentary evidence, and advisors now under scrutiny. The Supreme Court's next move will determine whether the extraordinary pace continues or slows. That decision will not answer every question, but it will define the boundaries of what happens next.